Howdy, my name's Mario, and I'm a licensed attorney in the state of Texas working with the Dallas Eviction Assistance Resources, or DEAR. We're here to give you legal information about evictions in Dallas. Although I'm an attorney, I'm not your attorney, and this video contains legal information, not legal advice. If you're looking for more free help with eviction or paying rent, please see the links in the description below. In this video, we'll go over how eviction works and what to do in court if you're being evicted. Now, the first thing we're going to talk about is notice. You'll know you're being evicted if you receive a notice of eviction. This may also be called a notice of termination or a notice of intent to terminate occupancy. The notice must be received by either the person who signed the lease or a person who lives at the same premises, which just means the place where you live, and is also 16 years or older. When you receive your notice to vacate, you can either vacate the premises, which means move out completely, or you can wait for the rest of the eviction process. If you choose to vacate, you have at least 3 days after you receive the notice to vacate, because the landlord must provide you with at least 3 days' notice. If you receive the notice of eviction by mail, the 3 days still starts the day you receive the notice of eviction, even if the landlord sent the notice ahead of that 3 days. If you do not vacate the premises when you receive the notice of eviction, the landlord cannot force you to leave or take your property until the eviction process has been finished in court. Now we're going to talk about the lawsuit, the eviction lawsuit. If you don't vacate the premises like the notice of eviction asks, your landlord must file an eviction petition, and this is what starts the lawsuit. The landlord must file the petition in Justice of the Peace Court. The landlord or a constable must serve you with a citation, a copy of the lawsuit, the date, time, and place of the eviction hearing. The hearing is typically set within 10 to 21 days after the lawsuit is filed. Now we're going to talk about your answer in response to the lawsuit. So to prepare for the eviction hearing, you should file a written answer as soon as possible with the court after being served with the lawsuit. You must file your answer within 14 days of receiving the petition to avoid a default judgment. A default judgment means you've lost by default, and by failing to answer the lawsuit, the court has decided without you, and they're going to decide against you. Before the eviction hearing, there may be a pre-trial conference or another hearing. Be sure to attend any and all hearings related to your eviction. These are extremely important for your case. If you're not a native English speaker, be sure to bring a translator with you. The court may not provide one for you. Filing the written answer and showing up to court are the most important ways to avoid a default judgment. Now let's talk about going to court. When you go to court for any pre-trial conference or for your eviction hearing, dress like you are going to church or to a job interview. You want to show the court that you're taking the process seriously. Dress conservatively, even if you don't have a suit. Don't wear hats or sunglasses, flip-flops, shorts, tank tops, pajamas, or t-shirts with sayings on them. If you are wearing a skirt or a dress, the bottom hem should go to your knees or lower. If you're wearing pants, wear a belt and tuck in your shirt. Try to cover up tattoos, minimize heavy cologne or perfume, and make sure your hair is well groomed. And bring layers just in case the courtroom is chilly. Now, what else should you bring to the courtroom? You should bring extra copies of all important documents, even if you've already filed those documents with the court. If you bring at least 3 copies of each important document, that will usually be enough. Some of the documents you might need to bring are a CDC affidavit, your lease, any proof of income, any proof of job loss, child support documents, and if you've had COVID, bring medical records to prove it. Bring a valid form of ID like a driver's license or a state ID card. Now let's talk about what not to bring. You shouldn't bring food or beverages, recording devices, or cell phones into the courtroom. Knives, pepper spray, sharp objects, and weapons of any kind are absolutely not allowed in the entire building. You'll probably have to go through a metal detector to get into the courthouse, so take this into account when figuring out what time you need to get there. And again, ensure you have no weapons on your person. So let's talk about how to address the judge. When speaking to the judge, you should stand up on your feet if you're able to. Call the judge your honor. Wait for your turn to talk, and listen carefully to make sure you answer any questions the judge asks you. Don't get off track when you're speaking to the judge. Think in advance about what you need to tell the judge, and be careful about what you say in open court. Let's talk about being on time. It is extremely important to arrive at your hearing on time. Get to the courthouse at least half an hour before your hearing begins. Remember to leave time for traffic and parking. Make sure you have planned out how to get to the courthouse and where to park. Consider driving there ahead of time to see how long it takes and how to get into the courthouse. Many lawyers do this to avoid being late. You want to be respectful at all times when you're in the courthouse. If you have brought your cell phone with you, make absolutely sure it is on silent before you enter the courtroom. Be respectful and polite to the people working at the courthouse. Stay calm and collected no matter what happens at the hearing. You may have to ask for other things from the judge in the future, so what you do at the hearing makes a difference. Remember to thank the judge and the court staff for their time. After the hearing, you should find somewhere quiet in the courthouse to take notes about what happened during the hearing. If the judge asked you for information or gave you instructions, write those down just so you don't forget. Make sure to avoid the following mistakes. Don't talk over the judge or the people on the other side of the case. Don't make faces, roll your eyes, or show when you feel frustrated or angry. Don't chew gum or eat inside the courtroom. Don't use your phone inside the courtroom. If you have an emergency or need to make a call, step outside. Don't tell any lies or try to hide information while you're under oath. At the end of the hearing, the judge is going to make a decision about whether you're going to be evicted or not. If the court orders you to vacate your home, that means you've lost the eviction lawsuit. However, you still have the right to appeal the court's order within 5 days. You have the right to remain in your home while the appeal is pending. Check out the links with this video if you have any further questions. Thank you very much.